Is it best to trade at the trust level or company level?
Okay. So I think that is a common question. People will come to you and say, listen, particularly where they're worried about tax, maybe also they're worried about protection of whatever the assets that will be either in the trust or a company. And I think when it comes to operating, I think ideally a company it's more advantageous, and I'll tell you why. One of the reasons why a company will be advantageous is because of established and more well-informed systems and policies that are out there that everyone is sort of accustomed to. For example, we know that there's a CIPC. If let's say you go to a bank or you go to sign an agreement with somebody, if I want to prove that this company is legit, I can easily go into the CIPC. I'll know the history about the company. I'll know the directors and all those things. But when it comes to trust, because of the confidentiality, because of the system that is still more a bit manual, I know that the Master of the High Court is trying to upgrade the systems such that they are more digital, but the system is still pretty much manual, such that it may be very difficult for people to actually trust. You don't even know when you are agreeing into a business contract with a trust, you don't know whether this person is giving you the latest trust documents or are these old trust documents as compared to a company. A company can get the latest information on the CIPC, then you can know that, okay, these documents that I'm contracting with are actually latest document. So I think this is where the disadvantage between a trust and a company is. Also, Companies Act has been tested many times in courts of law, so people are more comfortable with trading with it. Or rather contracting with it, because there are laws that have been established, and there are laws that they've been tested as compared to trust. Trust, yes, there's what you call Trust Property Control Act that governs the working of trust in South Africa. However, if you look at the legislation, it hasn't really been something that has been tested. So people are still uncomfortable to contract with trust. So for that reasons, I'll rather more prefer to trade with the company than a trust, and then maybe use trust for protection purposes.
So I would like to know, why would I register a trust if the tax rate is 45%?
Remember, at the end of the day, when you register a trust, you register for different reasons. In most cases, some people register trust for wealth protection, for continuity, for succession planning, things like that. So, and then as a result, it also helps with, in a sense, that when you use a trust, you must be careful of what type of income is going to get. So that's what tax planning is very, very important. Some people hold it as some form of a structure that holds operating entities, such that then those operating entities are the ones that are going to be taxed. And then the income that comes into the trust has already been taxed, such as dividend tax has already been taxed. Therefore, then the tax is not applicable. So that's why you find that 45% is not really relevant, because the income that comes into the trust has already been taxed. Therefore, people end up feeling that, you know what, okay, it makes perfect sense. So it depends on the usage. But then if now you're going to be operating within the trust, then that 45% is going to be more painful, because then it becomes quite expensive. And it goes back to that earlier question to say, should I be operating in the trust or the company? The tax rate is also going to be a consideration, so which makes a trust not favorable to be trading in it. But then what other people then do, they find that there's an income such as rental income that is sitting in a trust that gets to be generated in a trust. Instead of that income being taxed in the trust, they then distribute that particular income to the beneficiaries of the trust, and then those beneficiaries are the ones going to be taxed. So you may find that in some cases, those beneficiaries, they actually have a lower tax brackets, and they end up being the ones being taxed at those lower tax brackets. Then in that case, that 45% again is not going to be much, it's not really going to affect you that much.
And also, should I be a beneficiary?
Well, I mean, it depends on what do you call? It really depends on what you're intending to use that trust for. So if you are a founder, I presume that that question comes from, as a founder, can I really be a beneficiary? Yes, you can, So a beneficiary, basically, you as a founder of a trust, you can decide who's going to be a beneficiary. I mean, you can always make Shilipo also a beneficiary of the trust. Why not? So, but at the end of the day, yes, you can decide on who can be a beneficiary. You'll be a beneficiary if you want to benefit from that trust that you're founding, or you can decide that, listen, I want to make my wife and my kids only the beneficiary of the trust. That's really a decision of the founder.
And I know we actually spoke about this when you said some people create trusts to protect wealth and assets. So can a trust really protect my assets?
Look, it does give some form of protection. Depends on how you use a trust. That's why trust administration is actually becoming very, very, very important. And I'll tell you why. Where we're saying it gives a protections, let's say, for example, I'm in business and I then found a trust. And I say, listen, I'm going to transfer some of my assets into this particular trust. Then I move some of my wealth in that particular trust. If I respect and I administer that particular trust in such a way that there's a separation between me and the trust assets, meaning that there's no confusion whether the assets that are sitting in the trust are still mine or not. That's very important. In that case, yes, it can give you a level of protection should anything goes wrong in my businesses, meaning that should I get sued, or should I get into, or should I divorce, or for that matter, should I be sequestrated as a person, then it means that that particular trust assets could potentially be protected, provided that you did not create a confusion and blur the lines between you and the trust. The mistake that people then do, they'll form a trust and transfer companies and assets into the trust, but then you find that they're still behaving as if those assets are theirs. You find that they're still applying credit cards using the trust assets as if are theirs. They're still entering into form of business dealings and indicating to people, no, these are my assets. They're still using the trust assets without getting approval from the trustees. There's it's just nyaga nyaga, if I may use that word. There's just huge confusion that happens with it, and as a result, this is where then people end up having a problem, where then the asset protection that the trust was meant to protect, rather the assets that the trust was meant to protect, they end up not being protected because you created this huge confusion as to the separation between you and the trust. The fundamental principle is that you must make sure that there's a separation between yourself and those trust assets.
And also, what level of protection is there at the company level?
What level of protection
is there at the company level?
Look, there's an element of protection at the company level, in effect that you and the company, you still are two separate individuals, right? So a company will also enjoy that form of protection. Of course, that comes with it. However, also again, you should not be being seen to blur the line. And I think it goes back to that particular, that earlier question. You should not be seen such that there's a confusion between the company and yourself, and I think that's very fundamentally important. You find that you're even transacting through the company. There's a groceries and personal expenses that goes into the company. That on its own can create that huge confusion to say, what's really happening here? Who are these two? Are these two legal people separated? Because you know that company is a legal person per se. So you want to create that. You want to respect that. You want to make sure that a company is company. Get yourself a salary and move on. That's not you. Company is not you. You are not the company. In that case, then you'll create more and more protection. You'll enhance the protection that companies tend to have.
And does my personal affordability impact financing? And can I obtain when using a trust?
Look, you get people that will come and say, listen, I want to form a trust. And in me forming a trust, I want to buy properties, as an example, through a trust. Yes, because the trust doesn't have records, typically then the banks will typically then want to what do you call this? They'll typically wants to ask for affordability of the founding trustee, and things like that, similar to they will do with a company. When you want to buy a property using a brand new company, then they will typically ask you as the founder or a director of the company to say, listen, give us your affordability. That's very important. You need to be affordable. Your credit records needs to be obviously clean for you. So it's the same thing when you're a trustee and you're founder of the trust and you want to buy properties using the brand new trust. They'll want those affordabilities. That's very, very important that you've got affordability.
And how do I move the properties from my personal name once the structure is set up?
It's quite a technical one. It's not as straightforward if you want to optimize the taxes. But typically, there are three ways, if I'm not mistaken. There's a donation, where actually two. The other one is just an expansion of the other one. So it's typically a donation where someone then will say, listen, Shiluboy, I've got these assets, I've got properties, I've got shares, I've got all these things. I want to move everything out of my name for whatever reasons that I want, whether it's continuity, whether you want to bequeath all these things, you want to transfer this wealth for the next generation. You say, listen, Shiluboy, I really want to move all these things for the next generation. Therefore, as a result, I'll use the trust and then I'll bequeath everything to the trust, right? So they will typically then do the donations, and obviously then there's a donation tax implications that one needs to be mindful of. It can be very expensive. And then other people then will say, listen, let me rather sell everything. I still want the trust to pay me something, as much as it's my family's everything, but I need that money. So then that's where they'll typically then typically sell those, and then the trust will buy those assets from them. There will obviously be tax implication for potential capital gain tax may be applicable. Some of VAT might be applicable. Transfer duty may be applicable, depending on what is being moved from your name into the trust. So that's typically that. And other people that I've seen, they will do that because you find that a trust doesn't have money. Then they'll sell that in terms of loan, where now the trust owes you, it needs to pay you, say, over a month, over a period of time, right? In that context, then there may be some form of other tax implications that one needs to be mindful of, because we know that if you've got a trust has a loan that it owes one of the beneficiaries, or it owes trustees and things like that who are connected to that particular trust, there are certain tax implications that people need to be mindful of in that case, whether that loan is it be subjected to interest, those type of technicalities. So people need to be mindful of things like that. But I've seen where people also creating quite an advanced structures that we can't dwell into them now, but where such that there's shares, different types of shares being issued in exchange of assets being transferred into these structures. So it becomes quite technical. Typically people do that where there's like huge assets that are being transferred, but the normal properties just been moving around. It's quite a straightforward that you may find that an outright sale is actually still applicable, which can even allow you to release an equity out of that property that you're selling to the trust, and then can always utilize that money for other investments purposes, whether in a trust or in a personal capacity. So so those are simple, straightforward ways of transferring assets from your name into structures.
I also want to know about what happens if I set up a structure but it's dormant for a while. What happens with SARS?
Yeah, and it's actually a quite important question, because currently we're seeing that SARS is very aggressive. They're chasing their money. They are literally chasing their money. And one of the misconception that is out there, people think that if they are not trading, they don't have to submit returns. You are required to still submit tax returns even if you are not trading. So meaning that all your dormant, whether it's a trust, even if it's dormant, please submit your tax returns, because if you're not submitting your tax returns, you're potentially going to find yourself having those administrative penalties. That's very, very sensitive, and that's very important. The starting point is that trusts are not like companies. I know that SARS and the Master of the High Court are trying to work towards that, where they actually are going to trying to get trust such that trust, when they're registered with the Master of the High Court, they can automatically be, what do you call this? They can automatically be linked with SARS, and then you get tax number. Currently, as it is, you still need to get the letter of authority. Once you register a trust from the Master Court, you will receive what we call letter of authority, and then you still need to get the supporting documents, other supporting documents that you need to then register, what do you call this thing, and register with SARS. Therefore, upon you registering with SARS, you still need to submit your tax returns as and when they are due, even if you're not trading. So please ensure that you submit your tax returns.
And also, you mentioned that a bunch of people use their trust to say, "Oh, this is my trust, this is that." So I want to know is, how do I maintain control when there are other trustees involved?
This is where most people battle with. Most people battle with losing control or having a shared control. Maybe let's put a word, shared control. So now let's take a step back. Let's say I've got properties, rental properties as an example, and I'm trading in my name, or for that matter, I'm trading in a company which I own the company directly. I'll typically have this absolute control of what happens with these properties, particularly if they're in my name. I don't need to consult with anyone. I can do as I want, whether I sell, what I do. I don't need to consult with anyone. But one of the principles is that the moment you move the assets into the trust, you are basically bestowing those assets into the hands of the trustees, which means that now those assets are jointly owned and under the control of the trustees. Does not mean that the ownership in terms of the common law, that the moment you bestow all these assets into the hands of the trustees, does not technically means that the trustees then are economically entitled to benefit from those assets. And I think that's a principle that people need to understand. Therefore, those assets belongs to the trust. Yes, they're owned and jointly ownership is with the trustees, but then they're not entitled to benefit from unless they are the beneficiaries of that. So you'll typically not have absolute control. Yes, you'll have a control if you're a trustee because you are part of the trustees in the decision making. So you'll find yourself making the decisions as collectively as required by the trustee, by the law, that trustees must jointly and severally take decisions together because they're jointly and severally liable for whatever actions that are taking place within the trust. So you need to make the decisions as trustees. So you will have an element of control. You're not going to have that override control, because the mistake, if you, as earlier on, I answered the question around the issue of separation the two. So if you want to still retain a control, then you're going to have a problem because there's no separation between yourself and trust. You're still absolutely owning and controlling what happens with those assets. You are disregarding the other trustees. Then one can argue and say that trust is just nothing but an extension of you. Therefore, there's no separation between the two. So to avoid all these things, to avoid all this confusion, to avoid this thing of situation where there's no separation between yourself and the trust assets, you need to respect that. You need to accept that the moment you move assets into the trust, the control, as much as you're going to have it, is no longer the similar to the one where the assets are in your name, where you've got an absolute control. So you need to kind of make peace with that. And I think that's where most people battle with that. Yeah?
And also, why is the trust better? Why is the trust a better shareholder than me?
I think it goes back to that earlier discussion to say a person will typically get involved in multiple avenues or ventures. I could be an entrepreneur. I could be signing sureties, and you find that things don't go well, and then I get sequestrated. Then it means everything that I've owned will probably be taken. Secondly, I could divorce, and you find that now there's a divorce settlement that is not favorable, and then I end up losing those type of things. Or for that matter, I could have creditors that comes after me. There's a lot that can go on, can go wrong with a person. But another big one is when someone passes on, everything that you owned get to be frozen, right? Which is not the case with a trust. So when you passes on and things are frozen, those that are used to benefit from you may actually have negatively being affected by your death, because for them to continue living, they will need to apply to the Master of the High Court to be granted certain money, to be approved a certain money that they can utilize for their well-being. And it may not actually be to the level that they're accustomed to. And that's a very fundamentally important. So if your kids are used to be going to Maldives and Mauritius and New York as they please, they may find themselves not having to do all those things because your assets are frozen. They have to undergo the whole winding up of an estate. And this is where fundamentally, so the more you get richer, as you accumulate this wealth, it might be best suited for you to start having assets in or wealth in a separate structure such as a trust, such that it's much easier upon your death. These kids can continue to have the lifestyle that they're accustomed to, and there's no separation between their lifestyle with your death. And they can continue to go to Maldives after you're buried. They can continue to live the normal lifestyle, because we know that the winding up of an estate can take months or years, particularly where even there's a contestation of the estate. We've seen scenarios where now people are contesting these issues of deceased estate, and as a result, things can be prolonged. And when things are being prolonged, you can even lose wealth, by the way, because the moment there's a squabbles and there's a fights of these, you need lawyers. Lawyers need to be charged, need to be paid. And other scenarios where we've seen people losing wealth is when the process is taking a while to wind up the estate. Properties can be invaded, where things are gets to be stolen, and there could be a lot can go on when there's when you are in the moment of uncertainty. And disease estate, winding up of disease estate tends to have that uncertain moments, and as a result, this is where sometimes it's best to actually have a trust such that kids can continue to live their normal life. Things can continue as normal as if you're still alive.
I also want to know, can I make another trust a beneficiary, or is it a bad idea, or could it possibly
you can. I've seen such scenarios where, for example, someone gets too rich, and then they've got kids. Then they'll have master trust as a family. But because we know that kids at some point, they're going to have their own bloodlines. You've got 5 kids. Kids will typically then get married and have their own spouses and their own kids. So then people then typically what then they'll have this master trust, and then that master trust will then have a multiple trust below that for each kid. That is such that so that it allows those kids to also reinvest their own money and with their own kids and have their own life. But at the end of the day, you may find that there are certain assets and shares that are still sitting at the master trust that tends to benefit the kids. So it all depends on where you are in terms of wealth. And then other people, then you find that this trust, it also is more like too involved. Those trusts, you find that they're involved in terms of buying properties, they're involved in businesses and things like that. And then they will then also have what you call family trust, where it's sort of a bank, it's sort of a sacred place where it doesn't really get involved in the outside world. It doesn't really take into sureties. It doesn't get involved in taking debts. It's more preserving investments. All these dividends flows through the main operating trust into giving this one. And this one tends to invest in things that are subtle. You know what I mean? Like, it doesn't get involved in high risk investments and things like that. Is there one can use the better way to say it's a family sovereign wealth fund. It's like it's that place of sacred. It's not known. It doesn't sign documents. It doesn't get. So typically people do that. But obviously that comes with people that have got money. You know, a Shilly boy with 10 rand, I can't just go and say, I want to have 2 trusts, because administratively will be too much burden. The cost of paying accountants, the cost of paying tax advisors, the cost of paying the trustees may outweigh the benefits of having the 2 trusts. But like I said, yes, people do that. As long as you've got money, you can actually do those things. Yeah.
I also want to know, how many trusts do I actually need?
You need as much as your circumstances really deems it necessary for you to really have. Like I said, some people will have those 2, some people will have 1. And I think fundamentally also is that people need to understand that not every person needs to have a trust. I think that is very, very important. Not every person needs to have a trust. That's very, very important. So I think that's fundamentally important. So meaning that I may sit here as Shilly boy and you find that the trust is not best suitable for me, or you may find that someone else is suitable for them. For one, other people may have testamentary trust, which is a trust that tends to be formed upon death. You know, things like that. It all boils back to who you are. Is the trust suitable to you or not?
I also know we touched on it just previously. It's about companies. What are the tax benefits of a company?
There are various. And like I said earlier, if earlier on you heard, I mentioned that the company environment, the legislation that governs companies are well established in South Africa. Therefore, there's also various tax benefits and tax incentives that are out there that companies may enjoy. I mean, we've got what we call small business corporations, where if you are generating, you get favorable corporate tax rate. You get favorable if you buy certain assets that are falling within manufacturing or another different types of sectors. You get tax benefits in terms of deductions on those assets. More like you get deduction in a first year of trading as compared to another form of enterprises or companies. So there's quite a multiple tax benefits that comes with having a company, and it's just that they tends to change every year. Things gets to be updated and what do you call, things tends to be updated and changed there and there. So one just need to be mindful of that. But there's a lot of tax benefits depending on which sectors. Some are sector based. So if let's say you are in mining, you may find that there are tax benefits for mining. If you're in agriculture, property, I mean, for example, in property, if you buy properties in what you call urban development zones, there are certain tax benefits for that. If you buy properties in a low-cost housing space, there are tax benefits for that as a company can take advantage of. So there's quite a various tax incentives, that schemes that are out there that as a company you can take advantage of.
And can I make the trust the beneficiary of life policies?
Yes, I've actually seen that, and I'll tell you why people do that. Like I said earlier on, you find that you've got a life policy and you pass it on. That money goes into the estate. The number one factor is that executor will benefit from that, right? Because you would have not nominated anyone who's the beneficiary. In that case, then executor will benefit. But equally so, as I mentioned earlier, is that when you pass this on and there's a disease estate processes, the winding up of your disease estate, it may frustrate, it may take longer. Therefore, to avoid all these delays and frustration that your beneficiaries may suffer from, other people either they nominate a human person as a beneficiary, others they realize, hey, listen, it might not be a good idea to nominate my kids for the life cover because maybe my kids are not equipped in terms of financial literacy, or their kids. If I pass this on and my kids are below the 18, we know that in South Africa, a minor cannot inherit money. So meaning that it's either this thing, money has to go to under the guardian, or they must go to under guardian's fund. And I don't want that situation. Therefore, I've got these people that I trust. I've worked with them. I've, throughout the life, therefore, I've seen them as trustees. I've seen how they interact with my family, how they get along with my family. Therefore, I'm going to make my life policies, I'll take all my life policies, I'll make the trust beneficiary of that, such that even when I passed on, my kids can still distribute this money, being distributed this money by the beneficiary, and then they'll be well taken care of by these trustees within the trust. So yes, you can do that. And those are some of the reasons. Other people have got different reasons on why they'll make a trust a beneficiary of their policies. But definitely, most certainly, you can do that.
Also, you mentioned that some people end up getting a trust, but they don't need a trust. So what I want to know is, when is it better to have a testamentary trust?
So a testamentary trust is a trust that come to be formed upon someone passing on. I think that's a fundamentally important. So it will typically be formed. Some people will do that through it gets to be done via will. You'll sit down with your lawyer. You come and say, listen, I've got let's say, for example, minor children. I've got a minor children, and I don't want the situation where upon me passing, then there's a confusion, and these kids, either their money has to be under the guardian, or for that matter, like I said, it needs to be transferred to the guardian's fund. Sorry, and as a result, I then needs to form a trust, a testamentary trust upon passing on. Then what then typically then people will then do, that trust then will be formed in that. So typically you'll need that when you've got minor kids, where they can't inherit, like I said, they can inherit money and things like that. And you want them to be taken care of by the right people, because you may say, hey, listen, Shilebo, as much as I don't have money right now, but upon me passing, most likely I've got about 10 million. It could be from pension funds. It could be from life policies that you have. Some people typically will have money upon death because of the type of policies they have. Therefore, I don't want my kids being the one inheriting this, having this 10 million. So therefore, I need this to be administered by respectable and well-organized trustees. Therefore, let's form this trust upon death. So those will be typical reasons on that. Typically minor children, or for that matter, you've got kids with special needs. You know that if I were to pass on, this kid needs to be well taken care of. Therefore, I need to form a testament upon. Right now, I can't afford to form it, but upon death, all my assets and money that will probably be realized upon me passing on needs to be in a form of a trust, such that my kid with a special needs can be well taken care of. So that could be another reasons on why someone will need a testamentary. So it will typically be somebody who's going to have money upon death because of policies, but they can't afford to have a trust right now when they're still alive, because they can't afford to have administrative costs being covered. So it's around those. Sometimes those are the driving decision making those are some of the things that they consider before they make the decision. Yeah.
Also, I have one more question I want to ask. Let's say a person opens a trust, but they don't have any immediate family or a wife or kids, and they happen to pass on. What would happen with the whole trust?
So that is actually a brilliant question. So typically, where the last beneficiary but dies in a trust, that trust will typically have a clause. Some people will typically have a clause to say, upon the last beneficiary dying, and you don't have kids, they'll typically then go via the what you call Intestate Succession Act. What does that mean? It means that you'll be considered to have died as if you don't have a will, right? As an example. Then we'll have to go and find your aunt. We'll go and have to find your uncle. We'll have to find your cousins. I'm sure someone has cousins out there, but let's say in extreme case, we can't even locate your cousins. Then typically that money will go to government. So that government is always the last beneficiary. So that typically, but if let's say then you've got cousins and we can locate it, then we'll look at in terms of the Intestate Succession Act, we'll look at who in line has to benefit. There's a tree that needs to come. If this one is not alive, these ones. If these ones are not alive, these ones. If these ones are not alive, these ones. We'll eventually find the person who needs to inherit all your assets. Yeah.
Yes. Thank you so much.
No, thank you so much, Selby. Guys, that was Selby. I was having a conversation with Selby, who's our technical producer at the studio. So today we just felt that we need to do all those frequently asked questions around forming a trust. So you can, hope you enjoyed. If you've got a further question, you're more than welcome to share your own comment sections, and we gladly will answer those questions. Thank you.